establishing power of attorney, and then Dr. Joseph Chemparathy is going to talk to us about advanced care planning. It might seem like a faraway topic, and hopefully it is a faraway topic for all of us, but it's just good to think about and pre-plan, which is why we thought we could do this topic today. So we'll start with Chris,
excuse
and
me,
then
Dr. Mimi, excuse me.
Yeah.
Can you just ask others to mute the microphone?
Sure, yeah. Please mute. Please mute everybody. Thank you.
Okay.
And so I'll just ask Chris to start, and then after Chris is finished, Dr. Chemparathy will share his presentation as well, and then after that we'll take some questions.
Very good.
So once again, I welcome everybody in the name of the our new diocese to this fruitful session. Yeah.
Thank you, Pidave. Good evening, Pidave, Achamare, Pinne, Jerin, all our friends who are here. Thank you, Dr. Mimi, and a warm welcome and thank you to Dr. Joseph Chemparathy, who has so graciously agreed to co-present with me today. It's my honor to be presenting alongside you, Doctor. So without much ado, I will start with my presentation. I'll start by by sharing my screen. I'll try to keep it as brief as possible, Karanam, given the time constraints. For those of you who don't know who I am a lawyer. And ഞാൻ ഇവിടെ മിസിസാഗയിലാണ് എൻ്റെ ഓഫീസ്. നമ്മുടെ എപ്പാർക്കി, I'm a part of our eparchy, and a part of the SMYM group. So, I'm just happy to help however I can. So the first, നമ്മൾക്ക് ഒത്തിരി പേര് what is a will essentially? And ഞാനിന്ന് സംസാരിക്കാൻ പോകുന്ന മിക്ക കാര്യങ്ങളും will be pertaining to the province of Ontario. കാരണം your property or health related matters are governed by the provincial legislation. അതിനാൽ തന്നെ ഒൻറ്റാരിയോയ്ക്ക് ബാധകമായിട്ടുള്ള കാര്യങ്ങളാണ് ഇന്ന് നമ്മൾ സംസാരിക്കാൻ പോകുന്നത്. So essentially, what is a will? A will is a legal document that states who gets your estate after your death. So the underlying thing that we need to understand here is that will എന്ന് പറയുന്ന ഒരു സംഭവം will only come into effect after we pass away, അല്ല നമ്മുടെ കാലശേഷം. And estate എന്ന് പറയുന്നത് it is anything and everything that belongs to a person at the time of their death. And the governing legislation as far as Ontario is concerned, it is the Succession Law Reform Act 1990. Can you hear me?
Yes.
Keep going. Yeah, we're
yes,
good.
We can. There's a bit of a break, Chris. That's the only thing, but I don't know why. But go ahead.
Okay. I hope my internet connection isn't acting up. Okay. So who can make a will? So ideally under the law, anybody who's of the age of majority can make a will. And anybody who's underage can also make a will, provided he or she is married at the time or is contemplating marriage. And when it is the case where somebody is contemplating marriage, the will which is drafted will only come into effect or will be valid only if the marriage takes place with the person whom they contemplated to be married to. Or else they are a part of the Canadian Forces, which is governed by the National Defence Act. And while they are placed on active service under the National Defence Act, or is a sailor and at sea, or in the course of a voyage. Appam 18 വയസ്സിൽ താഴെയുള്ളവർ ഈ കാറ്റഗറി പെടുന്നതാണെങ്കിൽ മാത്രം they can make a will. അല്ലാത്തവർ you have to be at least 18 years of age to make a will. Next, why do a will? ഇതാണ് ഏറ്റവും പ്രസിംഗ് ആയിട്ടുള്ള ഒരു ചോദ്യം. പ്രത്യേകിച്ച് നമ്മൾ പുറത്തു നിന്നൊക്കെ ഇവിടെ ഇമിഗ്രേറ്റ് ചെയ്ത് വരുന്നവരുടെ മനസ്സിലെ ഏറ്റവും വലിയ ചോദ്യമാണത്. കാരണം നാട്ടിലൊക്കെ ഒരു 10-75 വയസ്സുള്ള ഒരാളല്ലാതെ ആരും ഒരു വില്ലുണ്ടാക്കി നമ്മൾ ആരും കണ്ടിട്ടുണ്ടാവത്തില്ല. വേറെ ഇവിടെ എന്ന് പറയുമ്പം ഒരു 10-28 വയസ്സുള്ളവർ തൊട്ട്, I'm just giving an age, as soon as you're settled, you buy a property here or you have children, immediately you think of making a will. And why is it important to do a will? Essentially, pratyech underage pillarullavaraanengil, it is very important to clearly mention aarayirikkum nammada kalashesham nammada pillarde legal guardians ennullathu. അതോടൊപ്പം തന്നെ നമുക്കിപ്പം ഒത്തിരി see, if you have a lot of beneficiaries in mind, then you want to avoid a potential conflict that could take place if you've not clarified how you wish to distribute your assets or your estate. Then it is important, ultimately it is your wish that has to be fulfilled in terms of the distribution. Appam, a will essentially helps you to do that, to let others know what is your desire. In some of the instances where, a will plays a crucial role is, under the law, only a married spouse can get property and not a common law partner. Karyam, nammade inganathe oru platformil ninnonde advocate cheyyunna sambhavam alla njan. I mean, I just wanted to highlight that these are everyday scenarios that I would face as a lawyer, that not everybody is in a married relationship, so to say. There are a lot of people who have common law relationships, who are in common law relationships. Appa under the law, common law relationship il ulla orakku automatically rights to the property illa. Only if you're married can you have some right to the property. Also, stepchildren cannot get property unless they are formally adopted. And another important reason why you need to make a will is to avoid delays or avoid too many expenses if you pass away without a will. Next, ഇത് വളരെ ബേസിക് ആയിട്ടുള്ള ചില കാര്യങ്ങളാണ്. Who are the people who come under a will? പലർക്കും അറിഞ്ഞുകൂടാ, നമ്മൾ ഈ ഓരോ പേരുകളെ ആൾക്കാർ കേൾക്കുന്നുള്ളൂ, പക്ഷെ they don't know what we mean by each of these people. So the first person is the testator. ടെസ്റ്റേറ്റർ എന്ന് പറഞ്ഞാൽ ആരാണോ വില്ല് ഉണ്ടാക്കുന്നത് അവരെയാണ് നമ്മൾ ടെസ്റ്റേറ്റർ എന്ന് വിളിക്കുന്നത്. ഫോർ എക്സാമ്പിൾ, ഇഫ് ഐ എം മേക്കിംഗ് മൈ വിൽ, ഐ ആം ദ ടെസ്റ്റേറ്റർ. ദെൻ ദ നെക്സ്റ്റ് പേഴ്സൺ ഇസ് ദി എക്സിക്യൂട്ടർ. എക്സിക്യൂട്ടർ എന്ന് പറയുന്നത് എന്റെ ആഗ്രഹങ്ങളെ എനിക്ക് വേണ്ടിയിട്ട് ചെയ്യുന്ന ആള് അല്ലെങ്കിൽ അത് ക്രമീകരിക്കുന്ന ആളാണ് ദി എക്സിക്യൂട്ടർ. Then the next is a legal guardian. Not every will have a legal guardian. Only if you have children who are underage, or you have somebody who needs to be taken care of, who's with a disability or something like that, they may have somebody like a legal guardian or a special trustee or something like that. Then the beneficiary. They are the most important people under the will, in a sense, because ultimately, ഇത് ആർക്കാണോ നമ്മൾ നമ്മുടെ പ്രോപ്പർട്ടിയും കാര്യങ്ങളും കൊടുക്കാൻ ആഗ്രഹിക്കുന്നത് അവരാണ് the beneficiary. And the witness. If we formal will, I'll come on to it in my next slide. Under the legislation, it is very important to have 2 witnesses present while you execute your will. If not, that will is not valid. So every will technically have the testator, the executor, and the beneficiary, the least. Now, types of legally valid wills. So in Ontario, there are 2 types of legally recognized wills. The first one is the holograph will, which is entirely, or as the legislation calls it, wholly handwritten, dated, and executed by the testator. And this requires no witnesses. നമ്മുടെ ഇപ്പോഴത്തെ ഒരു പ്രത്യേക സാഹചര്യത്തിൽ നമ്മൾ എല്ലാവരും കടന്നു പോകുന്ന ഒരു സമയത്ത് പ്രത്യേകിച്ച് ഐ ഹാവ് ഹാഡ് എ ലോട്ട് ഓഫ് ഫ്രണ്ട് ലൈൻ വർക്കേഴ്സ് ഓർ പീപ്പിൾ ഹു ആർ പാർട്ട് ഓഫ് ദി എസെൻഷ്യൽ സർവീസസ് who are so anxious, especially because they are parents to young children, underage children. അവർക്ക് ഭയങ്കര ആങ്സൈറ്റി ആണ്. Chris, we would like to make our will. How can you facilitate it? Of course, there are ways to facilitate it. പക്ഷേ if in any way this helps to take care of your anxiety, if it makes you feel better, please do at least a holograph will. It is not the most recommended type of will. It is going to be a very basic will wherein ഞാൻ ഇന്നാര് എന്റെ എല്ലാ പ്രോപ്പർട്ടിയും whatever I own ഞാൻ ഇന്നാർക്ക് കൊടുക്കാൻ ആഗ്രഹിക്കുന്നു, ആൻഡ് എന്റെ പിള്ളേർക്ക് ഞാൻ ഇന്നാരെ ലീഗൽ ഗാർഡിയൻ ആയിട്ട് അപ്പോയിന്റ് ചെയ്യുന്നു. It'll be a very basic will because naturally you all are not legally trained to use the language, but at least nevertheless it is still considered a legally valid will under the law. So complete item from the beginning to the end, it has to be in your handwriting. It has to be dated and it has to be executed towards the end of the will. Now, why is this not a very recommended form of doing a will? Because it can be easily contested. Ippam bhavil idine cholli issues undam that saying, this was not the testator's handwriting, or they did it with undue influence, or they were coerced to doing something like this. But it is very easily challenged. So just during this pandemic, at least, if it helps your cause or helps your case, please do a handwritten will. And once we resume things to normalcy, I would definitely recommend that you get a formal will done. But at least something is better than nothing. The next and the most commonly
Sorry,
done...
Chris, to interrupt you for a second. Can you just explain what you mean by dated and executed?
Okay, sure. So, for example, in April 27, so let's say Chris George Lamannil is making her will. So I am going to write the whole will. I'm going to make sure that towards the end, I date it as April 27, 2020, the date when I actually wrote it. And execute means putting my signature. That is very important. Without that, this will not be valid. Was that clear?
Perfect. Thank you.
No problem. Now, the second most commonly used form of will is the will made in the presence of witnesses, written by the testator or by an attorney or lawyer. It is dated and executed by the testator before two witnesses who have attained the age of majority. So, wherein, namali print cheyidipam where attorney ningalku vendi cheyyunna oru will avumbodethekine, it is dated and executed by the testator before two independent witnesses who have attained the age of majority എന്ന് പറയുമ്പോൾ minimum 18 വയസ്സുള്ളവരായിരിക്കണം witnesses ആയിട്ട് act ചെയ്യുന്നത്. So for example, let's say I'm making my will, and when I'm actually signing this will on the particular day, let's say my witnesses are Dr. Mimi and Dr. Chemparathy. So they have to be, under the law, the normal interpretation of it is that all three of us have to be physically in each other's presence when we do this. Like when I am executing and when they are witnessing, we all are supposed to be in each other's presence. That's how it is normally interpreted. I'm going to the next slide, and I'm going to explain the current situation also a little bit here. So what makes a formal will valid and the current situation? So a will is valid only if it is in writing. This is a very important factor that a will in writing it is not valid. Adipole, the execution of the will is to be witnessed by two witnesses, and the general interpretation under the law is that witnesses have to be the physical presence of the witnesses. Two witnesses is important. However, owing to the current situation, it is not practical or possible for people to be in each other's physical presence to do it. So a regulation under the Emergency Management and Civil Protection Act has permitted virtual witnessing of wills only during the duration of the pandemic. Of course, idinoru kaale alavu undu ingane cheyan pattunnadine, and virtually witnessing ennu parnale, for example, right now what is happening, I have Dr. Mimi and Dr. Chemparathy who are virtually present. They can see what I'm saying or doing. And ഞാൻ ഇവിടെ എൻ്റെ will execute ചെയ്യുകയാണെങ്കിൽ അവർക്ക് virtually അത് witness ചെയ്യാം. So ഈ rule pass ആയ സമയത്ത് the rule was that നമ്മൾ ഈ എന്താ പറയാ testator ഇത് originally sign ചെയ്ത് കഴിഞ്ഞിട്ട് ആ ഒറിജിനൽ വില്ലിന്റെ കോപ്പിയുമായിട്ട് നമ്മൾ ഈ വിറ്റ്നസ്സുകളുടെ അടുത്ത് പിന്നീട് ചെന്നിട്ട് അവരത് സൈൻ ചെയ്യുമായിരുന്നു. പക്ഷെ on April 24th, this legislation was being again updated, and they said now we can countersign it. So essentially, namakida scan cheydu koduthu the witnesses can also sign it. I mean, and all of this is really just a temporary arrangement, so that at least you can do a will during this emergency period, or alangi during this pandemic. And once things resume to normalcy, you have to get it redone, so that we do it the right way. And ingani virtually namal cheyumbodanile, it is important that one of the witnesses be a member of the Law Society of Ontario. It can be a lawyer or a paralegal. So I mean the witness who is witnessing you executing the will. Next is, what happens if you do not have a will? So if you die without having made a will, the law states that you have died intestate. And your property will be distributed as per the provisions of the governing legislation. So for example, I've just given a few examples here so that you understand as to what that means. If you die while legally married and have no children, your estate goes to your spouse. And this includes a spouse you're separated from, but not legally divorced. Now, പ്രത്യേകിച്ച് നമ്മുടെ കമ്മ്യൂണിറ്റിയിൽ ഇങ്ങനത്തെ ഒരു പ്രോബ്ലം നമ്മൾ ഇപ്പം കൂടുതലായിട്ട് ഫേസ് ചെയ്യുന്നുണ്ട്. Naturally, there is a stigma associated with legally getting divorced. അപ്പം നമ്മുടെ കമ്മ്യൂണിറ്റിയിലുള്ള ഒത്തിരിയും പേര് they prefer being separated from their spouses and whatsoever other reasons, they may not be legally divorced. And അങ്ങനെ ഇരിക്കുന്ന ഒരു സാഹചര്യത്തിൽ if you pass away without making a will, നിങ്ങൾ ഈ സെപ്പറേറ്റഡ് ആയിട്ടിരിക്കുന്ന സ്പൗസ് will be eligible, they would rightfully get your property, but it is not essentially your will that they should get it. So there is a good reason why you should make a will. Pinne, if you have a spouse and children, then if your estate is worth less than $200,000, your spouse gets everything. And if your estate is worth more than $200,000, your spouse gets the first $200,000, which is called the preferential share, and the rest is divided between your spouse and children. Essentially, this is also not a very desired way of doing it. And under the law, it is called preferential share. So only the first $200,000 goes to your spouse. It is probably everything that you've earned is together that you would have earned, and you would want your spouse to get 100% of it. But in this particular scenario, it will be divided between after the first 200,000, the rest will be divided between your spouse and children equally. Then if you're not legally married, but you have children, your children share your estate equally. So essentially, ഞാൻ മുമ്പേ പറഞ്ഞ പോലെ ഇപ്പം കോമൺ ലോ റിലേഷൻഷിപ്പിൽ ഉള്ള ഒരാൾക്ക് ആ ബന്ധത്തിൽ മക്കളുണ്ടായാൽ ആ മക്കൾക്ക് കിട്ടും ഷെയർ, പക്ഷെ ആ ഒരു കോമൺ ലോ പാർട്ട്ണറിന് കിട്ടത്തില്ല അണ്ടർ ദ ലോ അൺലെസ് യു മെയ്ഡ് എ വിൽ. പിന്നെ if you're not married and have no children, then your estate goes to your living closest relatives. And if you have no relatives, then your estate goes to the Ontario government. Now, this is the last thing that you would ever want to happen. Your hard-earned money, it is your choice as to what you want to do with it. Next, why should I involve a professional? Absolutely you can do your own will, but there are good enough reasons why you should get a professional involved. First and foremost, to help address the important aspects of making and drafting a legally valid will. Then secondly, to ascertain if you would need multiple wills. Ipo namak Ontario, we do have provisions of multiple wills, and this is more relevant to people who have ഒരുപാട് അസറ്റ്സും കാര്യങ്ങളും ഉള്ളവർക്ക്. This is a very valid and relevant point. കാരണം നമ്മൾ ഏത് വില്ലാണോ പ്രൊബേറ്റ് ചെയ്യുന്നത് ആ വില്ലിൽ നമ്മൾ ഏതൊക്കെ അസറ്റ്സ് ആണോ മെൻഷൻ ചെയ്തേക്കുന്നത് അതിൽ മാത്രമേ നമ്മൾ എസ്റ്റേറ്റ് അഡ്മിനിസ്ട്രേഷൻ ടാക്സ് കൊടുക്കുന്നുള്ളൂ. So to ascertain the taxation implications and guide the process of distribution accordingly, you definitely need to get a professional involved. Sometimes in our families, we may have people who have any disabilities or maybe children who are underage. Trust create you need to involve a professional. Estate administration tax, there is a certain calculation. So when a will is probated, estate in the value, we have to, calculation under, you have to pay for it. So essentially to minimize these costs or the estate administration tax, it is very important, and it is always advisable to involve a professional to wisely distribute your assets and decide as to what will be the best strategy in your particular case. Next, the power of attorney, I'm sure Dr. Chemparathy is also going to address. So I am going to keep it as brief as possible. So a power of attorney is essentially a legal document in which you give someone you trust, called your attorney, the right to make decisions for you in the event something happens to you while you're still alive. So let's say you're incapacitated, but you're still alive. So you're giving somebody the authority to make decisions on your behalf, just as how you would make those decisions for yourselves. The next is the different types of power of attorney, and primarily there are two, which is the power of attorney for personal care. I'm sure Dr. Chemparathy is going to talk extensively on the power of attorney for personal care. And the other is power of attorney for property. So the power of attorney for personal care is essentially a document where you name a person who can make decisions about your health care, housing, and other aspects of your personal life, such as meals and clothing, if you become mentally incapable of making these decisions. So a power of attorney for personal care essentially will come into effect only when you are mentally incapacitated to make those decisions while you're alive. Whereas a power of attorney for property is a document where you name a person who can make decisions about your financial affairs, including paying your bills, collecting money owed to you, selling your home, your managing your investments, etc. Anything and everything to do with your financial affairs. Now, a very important thing to note about the power of attorney for property is the minute you execute it, when I say executed, the minute you sign it, it comes into effect unless there is a clause that is specifically mentioned in that power of attorney. So either you have to be very mindful that it can come into effect immediately if it doesn't have the right clauses put into that power of attorney. So either definitely get a professional involved. Karanam, you are giving away too many powers to somebody and then you would stand to regret. So once again, I repeat that a power of attorney for property will come into effect immediately as soon as you sign it, unless there is a clause particularly mentioned within the power of attorney for property that it cannot come into effect unless you are mentally incapacitated or something of the sort.
Chris?
Yeah, that Jimmy said I'll take your question in a second. So that
Sure.
brings me to the end of my presentation. So I think Jimmy said I'm more than happy to answer your question, but I think it will be best if Dr. Chemparathy also did his presentation and if we did the questions at the end.
Okay. All right, that'll be fine. It's fine.
Thank you.
Okay. Thank you, Chris.
No problem, sir.
Good evening, everyone. And the screen on the thumb.
Dr. Chemparathy, at the bottom of your screen, you should see an icon that says share screen, like a green button.
Yes, I saw that.
Just try clicking that and see.
Yeah. Okay.
Perfect. Now you just open your presentation.
Okay. So എൻ്റെ പേര് ജോസഫ് ചെമ്പരത്തി എന്നാണ്. ഞാനൊരു ഫാമിലി ഡോക്ടർ ആണ്. ബെർലിംഗ്ടണിൽ പ്രാക്ടീസ് ചെയ്യുന്നു. അതുകൊണ്ട് തന്നെ ജെറിനോടും ഡോക്ടർ വിപിതയോടും പിതാവിനോടൊക്കെ എൻ്റെ നന്ദി രേഖപ്പെടുത്തുന്നു എനിക്കിങ്ങനെ ഒരു അവസരം തന്നതിന്. Okay, and so we'll go into the topic. So the topic is advanced care planning. നമ്മുടെ മലയാളികൾക്ക് എത്രമാത്രം പരിചയമുള്ള ഒരു സംഗതിയാണ് ഇത് എന്ന് എനിക്കത്ര ഉറപ്പില്ല. നമ്മുടെ ഇടയിൽ ചിലരെങ്കിലും ഇങ്ങനെയൊരു സംഭവം ആദ്യമായിട്ടായിരിക്കും കേൾക്കുന്നതെന്ന് എനിക്ക് തോന്നുന്നു. സോ അതുകൊണ്ട് ഞാൻ കുറച്ചൊന്ന് വിവരിച്ച് പറയുകയാണ്. സോ ഇതിന്റെ അർത്ഥം മനസ്സിലാക്കാൻ നമ്മൾ ഈ അഡ്വാൻസ് കെയർ പ്ലാനിങ് എന്നുള്ളത് ഈ വേർഡ്സ് ഒന്ന് റിവേഴ്സ് ചെയ്ത് പറഞ്ഞാൽ കുറച്ചും കൂടെ എളുപ്പമുണ്ട്. അതായത് പ്ലാനിങ് ഫോർ കെയർ in advance. Care എന്ന് പറയുന്നത് it is personal care. So planning for personal care in advance. അതാണ് അതുകൊണ്ട് ഉദ്ദേശിക്കുന്നത്. നമ്മൾ എല്ലാവരും അല്ലെങ്കിൽ മിക്കവരും തന്നെ ഇപ്പോൾ നല്ല ആരോഗ്യത്തിലും നല്ല സ്വഭാവത്തിലും ഇരിക്കുന്ന ആൾക്കാരാണ്. പക്ഷേ നമ്മളെപ്പോഴും അങ്ങനെ ആയിരിക്കണമെന്നില്ല. നമുക്ക് അപകടങ്ങൾ ഉണ്ടാവാം, അല്ലെങ്കിൽ സീരിയസ് ആയിട്ടുള്ള അസുഖങ്ങൾ ഉണ്ടാവാം. ഉദാഹരണത്തിന് ഇപ്പോൾ ഒരു COVID-19 അസുഖം വന്നിരിക്കാം. നമുക്ക് ചിലപ്പോൾ ക്യാൻസർ പിടിപെട്ടെന്ന് വന്നേക്കാം. അങ്ങനെ പലതും നമുക്ക് സംഭവിക്കാം. അങ്ങനെ സംഭവിച്ചു കഴിഞ്ഞാൽ നമ്മളുടെ ബോധാവസ്ഥയ്ക്ക് മാറ്റം വരും. ഇപ്പോൾ നമുക്ക് നമ്മളുടെ പേഴ്സണൽ ഹെൽത്ത് കെയറിനെ പറ്റിയുള്ള ഡിസിഷൻസ് ഒക്കെ എടുക്കാൻ നമുക്ക് മുഴുവൻ പ്രാപ്തിയുള്ളവരായിരിക്കും. പക്ഷേ ഇങ്ങനെയുള്ള അവസരങ്ങളിൽ ആ പ്രാപ്തി നമുക്ക് നഷ്ടപ്പെട്ടെന്ന് വരും. ആ സമയത്ത് എന്ത് ചെയ്യും? ആര് നമുക്ക് വേണ്ടിയിട്ട് തീരുമാനമെടുക്കും? ആ തീരുമാനം എടുക്കുന്ന ആള് നമ്മളുടെ ആഗ്രഹം പോലെയോ അല്ലെങ്കിൽ നമ്മളുടെ ബിലീഫ്സ് അനുസരിച്ചൊക്കെ ആയിരിക്കുമോ കാര്യങ്ങൾ ഡിസിഷൻ എടുക്കുന്നത് ഇതൊക്കെയാണ് വളരെ പ്രസക്തമായിട്ടുള്ള സംഗതികൾ. അപ്പോൾ അതിനുള്ള ഒരു പ്രിപ്പറേഷനാണ് ഈ അഡ്വാൻസ് കെയർ പ്ലാനിങ്. So let's go into the details. So advanced care planning in the definition ആണ് advanced care planning is about preparing you and your future substitute decision maker or makers for a time when you may not be able to make your own health or personal care decisions because of your lack of mental capacity. At that time, your future substitute decision maker would step in to give or refuse consent for treatment. So I think it is clear. Description. We'll go to the next slide. I'm sorry, there's one in between. So advanced care planning is about preparing you and your future substitute decision makers for a time when you may not be able to make your own health or personal care decisions because of your lack of mental capacity. At that time, your future substitute decision maker would step in to give or refuse consent for treatment. Another slide, let me see them. Okay, and we'll slide here, miss that. I'm sorry about that. So the advanced care, this is the definition. Advanced care planning is not an event, but a process of reflection, communication, conversation, and planning by capable adults at any age or stage about their beliefs, values, and wishes for a time when they will no longer have the capacity to make a decision about their own health care. Discussions focus on future healthcare wishes. So നമുക്ക് സ്വന്തം ഡിസിഷൻ എടുക്കാൻ പറ്റാത്തൊരവസ്ഥ വരുമ്പോൾ ശരിയായിട്ടുള്ള നമ്മളുടെ ആഗ്രഹം പോലെയുള്ള ഡിസിഷൻസ് ഒക്കെ നമ്മളുടെ സബ്സ്റ്റിറ്റ്യൂട്ട് ഡിസിഷൻ മേക്കർ എടുക്കാൻ വേണ്ടിയിട്ട് അവരെ പ്രിപ്പയർ ചെയ്യുന്ന ഒരു ഇതാണ് അഡ്വാൻസ് കെയർ പ്ലാനിങ്. So advanced care directive, that is something slightly different. It's some form of communication. It can be written or oral that allows a capable patient to provide guidance to their healthcare provider or substitute decision maker regarding future healthcare decisions and once they are no longer capable. So ഇതിന് ഒണ്ടാരിയോ പ്രോവിൻസിൽ ഒരു ലീഗൽ സ്റ്റാൻഡിങ് ഇല്ല എന്നാണ് ഞാൻ മനസ്സിലാക്കുന്നത്. എന്നാലും നമ്മളുടെ ആഗ്രഹം പോലെ നമ്മുടെ സബ്സ്റ്റിറ്റ്യൂട്ട് ഡിസിഷൻ മേക്കർ ഡിസിഷൻസ് എടുക്കാൻ വേണ്ടിയിട്ട് അവരെ ഒന്നുകിൽ റിട്ടേൺ ആയിട്ട് കൊടുക്കാം, അല്ലെങ്കിൽ അവരെ പറഞ്ഞൊക്കെ മനസ്സിലാക്കി വെക്കാം. അതാണ് അഡ്വാൻസ് കെയർ ഡയറക്റ്റീവ്. USA ഇതിന് ഒരു ലിവിങ് വിൽ എന്ന് പറയും. ആൻഡ് ഐ തിങ്ക് ദർ ഇസ് എ ലീഗൽ സ്റ്റാൻഡിങ് ഫോർ ദിസ് കൈൻഡ് ഓഫ് എ ഡോക്യുമെന്റ്. Coming to substitute decision maker. ഇതിന് പല പ്രോവിൻസിലും പല പേരുകളുണ്ട്. In Ontario, substitute decision makers are called the attorney. So these are persons who will make treatment and personal care decisions if the patient loses the capacity to make these decisions in the future. In most jurisdictions, if there is no legal document giving another person the authority to make decisions, this person is determined by a hierarchy of relationship. So, നമ്മളിപ്പം ഒരു പവർ ഓഫ് അറ്റോർണി ഒന്നും എഴുതാണ്ട് ഒരു സബ്സ്റ്റിറ്റ്യൂട്ട് ഡിസിഷൻ മേക്കർ വെക്കാണ്ട് നമ്മൾ സപ്പോസ് you become unconscious or you lose your ability to make decisions, then the decision maker will be under, according to this hierarchy of relationships. We'll come to that later. Power of attorney for personal care. So it's a document in writing in which you name someone to be your attorney. So the word attorney doesn't mean that it's a lawyer. In this case, an attorney is a type of substitute decision maker. അതിന് ഒന്റാറിയോയിൽ ഈ സബ്സ്റ്റിറ്റ്യൂട്ട് ഡിസിഷൻ മേക്കറിനെയാണ് അറ്റോർണി എന്ന് പറയുന്നത്. Now let's see what are the qualities of a good substitute decision maker or attorney. So first of all, they should be willing to accept the role and make future decisions regarding the patient's health care. He should be able to discuss and understand patients' goals, values, and beliefs. Because when they make decisions for the patient, that should be based on the patient's beliefs or the patient's desires, not according to what he thinks is right. And he should have an ability to advocate for the patient and make difficult decisions. And he or she should meet the legal requirements in the province or territory. So what are the requirements of a substitute decision maker in Ontario? Should be a mentally capable adult who is able to understand the treatment, the care being proposed, and appreciating the consequences of consenting or refusing the treatment decision. At least 16 years old, not prohibited by court order, and he or she should be available in person, by phone, or via electronic communication. And of course, they should be willing to act as a substitute decision maker. So for a power of attorney to be valid, the document must be signed by you voluntarily of your own free will. It should be signed by you in the presence of 2 witnesses, be signed by the 2 witnesses in front of you. You must also be mentally capable of understanding and appreciating the kind of document you're signing and what you're doing by signing such a document. So let's see what decisions the attorney can make for you when you are not able to make that decision. They can consent for tests, for surgery, for other procedures, or other medical care. They can starting or refusing treatment, or withdrawing life-prolonging measures. So that's a very important thing. Like if you're unconscious, for example, you have cancer and you have reached the terminal stage and eventually you lose consciousness. And then say, for example, the doctor says, you feeding tube iduvaanundengil korchu kalam കൊണ്ട് ജീവിക്കും, appo adu veno vendeyo, unless you know what the patient would have wanted if they were capable, അറിഞ്ഞാലേ അത് ശരിയായിട്ടുള്ള ഡിസിഷൻ എടുക്കാൻ പറ്റുള്ളൂ. അങ്ങനത്തെ ഡിസിഷൻസ് ഒക്കെ എടുക്കുന്നത് is the substitute decision maker. They can also take decisions regarding admission or discharge from a medical facility, also in moving into or receiving personal care in a long-term care home. So all such decisions are taken by the substitute decision maker if you are not capable. Now, this is the hierarchy of STMs in Ontario. The first 3, these 3 are appointed by the court, or it's legally appointed. First will be, if the first applies mostly to people who don't have any family or friends. And if such a person becomes unconscious, usually the court will appoint a guardian and he will be the person who takes decisions. Otherwise, an attorney named in a power of attorney, like if you have made a power of attorney, that attorney will be the person, will be the legally responsible person for you. Or it can be a representative appointed by Ontario Consent and Capacity Board. Now, these are the substitute decision makers which come automatically based on the family relationship. So first will be your spouse or partner. If such is not there, then it will be your child or children or your parents. In case of children who are taken over by the Children's Aid Society, they will become the decision makers. And then a parent who has only right of access, again, in case of children, a child, if the parents are separated and the person who has the custody is not available, then the other parent who might have only a right of access will become the STM. Then comes the siblings. So all the siblings will have equal, say, right to be the STM. So usually they will have to agree on decisions. Or if there are, say, 3 or 4 of them, they can all get together and appoint one of those people as the STM, and he will be the one who takes decisions. So all these come into effect only if you have not made a power of attorney. And if you have made a power of attorney, then that person will be the STM. And if the sibling, after that comes the siblings, and if siblings are not there, any relative, and as last resort, the public guardian or trustee will be the STM. So what are the benefits of advanced care planning? So that will give an incentive for more people to engage in conversations about end-of-life preferences and complete advanced care directives and identify a substitute decision maker. And it will usually lead to less aggressive medical care and better quality of life near end of life. For example, if you have, say, a terminal illness, you will not want your life to go on forever. You will like to go through go for a natural death process. So unless you have made those wishes clear, then there is a possibility that your case will be treated very aggressively, even though the quality of life is very poor. Whereas if you have given proper direction to the STM, then that should not happen. It will lead to decreased hospital admissions, less time spent in hospitals, and increased rate of hospice admissions. And there's a higher likelihood of receiving care aligned with patient wishes. Also, the families are better prepared to deal with the death of a loved one and to resolve conflict and to cope with bereavement. Again, why is advanced care planning important? In Ontario, the law requires all healthcare providers to get informed consent or refusal of consent before providing a patient with any treatment or care. Health practitioners must tell you about your illness and what they may do to treat you. So they are obliged to tell you what are the benefits of doing an intervention, or what are the risks or possible complications of doing an intervention. And then you are the one who has to decide whether you should go ahead with that intervention or not. And you have the right to make a decision and agree or refuse treatments offered. If you're not mentally capable, the health practitioner will turn to another person, usually your substitute decision maker, who will then speak for you and make the decisions about your care. So as an STM is needed in such a situation. Again, the STM kicks in only when you become incapable or when you lose your capacity for decisions. So who decides whether you are capable or not? So for healthcare, the healthcare provider proposing the treatment will determine if you are mentally capable of consenting or refusing treatment. If you are found incapable, then you have if you are found incapable but you don't agree with it, then you have the right to ask the Consent and Capacity Board to review that finding. Now, cardiopulmonary resuscitation. I included this in this topic because that is an important aspect of the whole advanced care planning. So in serious illnesses, in the terminal stages, if, say, you stop breathing or if your heart stops beating, then whether one should try to revive you, that depends again on your wishes. So the term cardiopulmonary resuscitation is often used to describe the treatment to restart a person's heart after it has stopped beating, or give artificial respiration to a person who has stopped breathing. So these situations can be due to unexpected events like drowning or accidents or a heart attack, or it can be because of other serious illnesses of a chronic nature, heart disease, kidney failure, pneumonia, blood infections, cancers. Very often in the terminal stages, these situations can arise. So the cardiopulmonary resuscitation can involve chest compressions to keep the blood flowing, artificial respiration, electric shock to the heart to make it beat again, or external pacing of the heart. Again, if the heart is not beating, then with pacing you can make the heart start beating again. Or injections of many drugs into veins or even the heart directly. So that is cardiopulmonary resuscitation. Again, now many patients who have, say, incurable diseases like cancer, they will probably decide if they stop breathing or if the heart stops beating, then they don't want any attempt to restart the heart, or they don't want to go on a ventilator, for example. So that is called allow natural death. And it all depends on what you want or what your beliefs are or what your goals are. So there are many things to consider when you say that you don't want any resuscitation. So most people want to be comfortable and suffer as little as possible. You don't want to prolong life if the quality is very poor and if you're suffering. Others might want more time with family. So like for, say again, conditions like cancers, if they want to prolong life, you might have to go for a lot of, say, injections and medications and things like that. And for that, you might have to stay in the hospital for a long time, which many people may not want. They might want to spend the rest of the time with the family and die peacefully at home. And then, of course, they will like to have no resuscitation if something happens to them. Whereas others might want to live as long as possible. They might say, okay, you go, you do resuscitation if something happens to me. Others might want to, say, die with dignity and would like to avoid being attached to machines and tubes. prolonged death, of course, nobody would like that. And all these interventions can prolong death, and they might say, I don't want that. Some people might have the belief that life should be preserved at all costs, that it is very sacred, and I mean, everything should be done to preserve life. And some other people might want to respect the wishes of other family members. They may not want to continue as a burden to the family. So all these things are to be considered, or they come into play when you decide to have CPR or not, allow natural death or not. Very often when you go to a hospital, for example, they will ask you what you want, whether you want resuscitation or not. We generally call it the code status. At least some of you might have you must have heard these announcements when you walk in the hallways of the hospitals, like code blue, floor 3, bed 4, etc., etc. So code blue means somebody has stopped breathing, or the heart has stopped, and they're calling the doctors and the other healthcare workers to come running to resuscitate the patient. So if you're going to the hospital, particularly if you're old or have a serious illness, they'll ask you what you want. And if you say that I don't want any resuscitation if the heart stops or you stop breathing, then they will write it on the chart saying that it is DNR. That means if you stop breathing or something, then don't call code blue or anything, or allow natural death. The term allow natural death, it is a little more encompassing. It means don't do CPR, and also don't do any life prolonging treatment to allow the disease to take its natural course and allow natural death. So this is a form called Do Not Resuscitate Confirmation Form, and this is in the province of Ontario. This is mainly meant for emergency medical services people, like paramedics and other emergency workers. Suppose you have somebody at home who is very ill, and who is not expected to live long, and say something happens, like for example if they start vomiting blood, so whoever else is there at home might feel scared, and they might call 911, and the paramedics will come running. And if the patient is not breathing, they will immediately start CPR. That is the protocol, unless you have a form like that filled out, and this has to be signed by your doctor or a nurse. And each one, you can see at the top right corner, there's something called the serial number. So it is unique. You can't print it out of the computer and fill it out and get it signed. This form has to come from the municipality itself. So if there is somebody like that, and you if the paramedics come, you don't want them to do a CPR, this form should be available there. The paramedics won't take your word and stay away from doing this. You have to show this form. So it has to be near the patient at all times. And this is one poor lady who has advanced cancer, and she didn't want any resuscitation done, and she wanted to make sure that paramedics and people who might come to her house, if somebody calls, won't do the CPR, and she had this hanging from her neck all the time. And okay, so that finishes my presentation. Now open for questions.
Thank you, Dr. Chemparathy. Thank you, Chris. I'll start with Jimmy Uncle just because I think he had some comments and to make at first, and then we'll ask others as well.
Thank you, Dr. Mimi, Dr. Joseph Chemparathy, my good friend, Chris Lamannil, also my neighbor and my good friend, and also especially to Bishop Joseph Kalwell for organizing this extremely informative session, especially again, George Chambarnevale. Even for youngsters as well, which is quite clear, I think, from what I hear, especially with the COVID-19 situation. I think, firstly, either I'm not sure whether you have taken this, a little, in the sense, not just into this audience. Have you presented this to the church audience? I don't think so as yet. I'm not sure whether you have done it.
Jimmy Cheta, ennodano? I had once addressed a session on wills for the seniors, Karnyorsham. Yeah, but that was only the seniors, not, sorry, they're called the pioneers. My mistake, sorry.
Also, I think I don't think many people are aware of these things. These are very important things. And I'll give you without a doubt.
ഒരു ഫോണിലാണ് ഞാൻ കാര്യം പറയാം.
ഓക്കെ, അപ്പൊ ഞാന് ഇൻഫാക്ട് വിനീതും ബാക്കി SMYM പിള്ളേരെല്ലാം ഉണ്ടല്ലോ, അതുകൊണ്ട് ഐ ഹാവ് ടു ടെൽ യു എ സ്റ്റോറി. ഇറ്റ്സ് ഇമ്പോർട്ടന്റ് ടു നോ ദിസ്. എന്റെ വൈഫിന്റെ ബ്രദറിന്റെ ദാറ്റ് ഇസ് മൈ നെവ്യൂ നിതിൻ എന്ന് പറയും. അവന് May 23rd, 2018 he had a motorbike accident. In fact, it was just on a side road. I won't go into the details anyway. He hit a 16-year-old girl who crossed the road without even looking. Hit the car, flew into the air 25 meters, and it fell on the ground. And then, of course, he had his helmet. He was conscious, taken to the hospital. He was, of course, conscious, but hospital. And then the next day, he went into So he went into a coma. Okay, so the reason is I forgot what's the term. Dr. Joseph Chemparathy will know. It was actually the cells, the bone marrow actually escaping. It went into the brain and caused this. It caused the coma.
Fat embolism.
Sorry.
Fat embolism.
Exactly. Fat embolism. So thanks for saying that again. So it became fat embolism. So what the story behind this is actually, again, so he went into coma, and even today he's in a vegetative state. Remember, 34-year-old young man, fully alive, fully ready to get married the next month in India. Anyway, why I said the story is that, fortunately for him, he had a last will, he had a personal care, and also the power of attorney for the property. Chris also Dr. Chemparathy who are you? Even parents also, they don't have the right to decide what treatment should be there or not. Fortunately, because his father is very strict about these things, he made me also take it just for information. But just a simple thing, I think that's why I'm coming to you as a question. The power of attorney for property. When they went to the bank, they said, I'm sorry, it has to be notarized. The power of attorney, you said 3 documents, right? That was not notarized. So TD Bank, to tell you the story, the TD Bank did not want to give it the money. Comments on it?
So essentially, it has to be witnessed, the power of attorneys. Adipa personal care ayalum, for property ayalum, it has to be witnessed and generally when you get it done with the help of a professional, we will always do something called an affidavit of execution. So we will have one of the witnesses who signs, do an affidavit stating that they were present when the person made their power of attorney or made the will. And that is good enough proof. You don't need that particular document per se to be notarized as such, but there are certain institutions that do have certain requirements. This is just to make sure that it was really legitimately done. Karna, it is property, and as I earlier also mentioned, for property, unless there is a particular clause mentioned in it, if it is signed by the person and there are witnesses to it, it immediately comes into effect. So yes, institutions do take extra precaution, and we generally do it with the help of an affidavit. Like anybody who does the will or the power of attorneys, and we do have supporting affidavits that go along with it.
Yeah. The other question is that we talked about the will, and just tell me in case I'm taking too much of time, just you can stop me short anytime. Is it necessary for this to be notarized or not?
In Ontario, under the law, there is no requirement for the will to be notarized, but it has to be witnessed by 2 witnesses for it to be legally valid.
Okay.
And this
Another
is
question.
And this is for the formal will that you would normally do in a normal day, not the handwritten. The handwritten will does not even need those witnesses. It just has to be handwritten wholly. Like everything about the document has to be handwritten right from the beginning to the end, and it has to be signed by the testator and dated as well.
Okay. The power of attorney for property, would that mean the bank account as well?
Yes. The power of attorney for property essentially covers everything, real property, personal property, everything. Unless it is a power of attorney that is specifically made for any specific reasons, and those would definitely have a very specific clause. Like, പക്ഷെ അല്ലാണ്ട് ഇപ്പൊ നമ്മുടെ ജനറൽ പാർലാൻസിൽ ഇപ്പം നമ്മൾ ഈ ഡിസ്കസ് ചെയ്ത ഒരു ടോപ്പിക്കിനോട് റെലവെന്റ് ആയിട്ടാണെങ്കിൽ പവർ ഓഫ് അറ്റോർണി ഫോർ പ്രോപ്പർട്ടി വിൽ ഇൻക്ലൂഡ് real as well as personal property, which includes your bank accounts, your investments, your house, everything.
Okay. Now for the to Dr. Joseph Chemparathy. Now this is again with regard to our SMYM, the international students and our youth here, who are probably all single, especially in the COVID-19 days. The advanced care planning, also power of personal care. Let's say, to give an example, a bachelor over here, can he or she get a power of attorney for personal care and signed by a friend?
So the power of attorney is a legal document. Just like the will, it has to be signed in the presence of 2 witnesses, and the 2 witnesses should sign in presence of whoever is making the power of attorney.
Sorry, go ahead.
Yeah, that is the legal requirement. I don't know if Chris has to add something.
No, sir, absolutely. It just has to be witnessed. And I would always say that Sir Mumbai Parnarano witnesses and preferably who are over the age of 18. And they can be absolutely anybody. As far as a power of attorney is concerned, they could be your friends, they could be anybody. But when you are taking people to act as witnesses under a will, I would be very careful, because an executor can act as a witness, but a beneficiary or the beneficiary's spouse cannot act as a witness. That's very important to note.
Okay. That's all for me. Thank you.
Thank you, Jumianko. Thanks. Yeah, thank you for the good questions. Anybody else with questions?
Yeah, hi, Saju here.
Hi, Saju.
Hi. Thank you so much, Chris and Dr. Joseph, for the session. My question is for Chris. We heard of a couple of roles like legal guardian, power of attorneys, and in fact the SDMs. So, like, is there any restriction that either of these roles, a legal guardian or a power of attorney, they need to be a Canadian? Can it be any of our siblings who are non-Canadians and are in India. For example, our situation, like people who are back home. So having this, giving this legal guardianship or a POA in either of the scenarios, will they be entitled for all for acting in Canada over here, or it has to be precisely a Canadian over here, a PR or a citizen?
So Sajid, to answer your question, under the law, there is nothing that states that somebody who is not a Canadian cannot be named as a legal guardian or cannot be named as an attorney or an SDM. Dr. Joseph, please correct me if I'm wrong. So there is no legal requirement per se, but there are practical implications. Like, for example, you can have, now this particularly I have had, very recently I've had a lot of families, young families who are immigrant families, and they particularly do not have family members here. അപ്പം അവർ ചോദിക്കുന്നുണ്ട് ദാറ്റ് ഞങ്ങളുടെ പിള്ളേരുടെ ലീഗൽ ഗാർഡിയൻഷിപ്പിന് ഞങ്ങൾ പേര് കൊടുക്കുമ്പോൾ ഞങ്ങൾ ആരെ ആയിരിക്കണം. അപ്പം ഞാൻ അവർക്ക് കൊടുക്കുന്ന ഒരു ഗൈഡ് ലൈൻ ഇതാണ്, that you can have two types of guardians. One is a temporary legal guardian whom you can name, who can be a very good friend of yours, who can be somebody who's out here, who can immediately help you in the event of an eventuality, or rather step up in the event of an eventuality. And then you can have a permanent legal guardian named, who can be your parents, siblings, whoever are located wherever, so that you give them that time. Karanam porthulla oralu ultimately physically they have to get here to do those things on your behalf, right? Appo adu just nammalonu practical perspective il ninnu chindikkumbom it will be good to have a temporary legal guardian and a permanent legal guardian. And I always say that legal guardians ne nammal name cheyyumbom nammal eppozhum aalochikkendathu, will they step up in the hour of need? Are your kids comfortable with them? Do you trust them enough with your kids? അപ്പം ഇത് വളരെ ഇമ്പോർട്ടന്റ് ആയിട്ടുള്ള ക്വസ്റ്റ്യൻസ് ആണ് when you think of legal guardians for your children. And as far as an attorney or an SDM is concerned, under the power of attorneys, I would again think for practical purposes it would make sense to name someone who is here physically present, because again in the event of something of the sort happening, then you want somebody who can immediately act for you. So if they are physically present here, again, it just helps practical in the practical scenario. And I'm sure Dr. Joseph would like to add on to that.
This idea, I agree. SDMs should be available. The doctors or the other healthcare workers should be able to contact you. See, suppose a person is unconscious and you want to ask for directions of treatment. The SDM should be somebody whom they can contact easily. നാട്ടിലുള്ള ആളാണെങ്കിൽ കോണ്ടാക്ട് ചെയ്യാനും ഒക്കെ ബുദ്ധിമുട്ടായിട്ട് വരും. സോ അതിന്റെ ലീഗാലിറ്റി എനിക്ക് അറിയാൻ പാടില്ല, പക്ഷെ ഫോർ പ്രാക്ടിക്കൽ പർപ്പസസ് ഇറ്റ്സ് ബെറ്റർ ദാറ്റ് ദേ ആർ ഹിയർ ഇൻ കാനഡ.
I think Abi Saban had raised his hand. Do you have a question?
എനിക്കൊരു ക്വസ്റ്റ്യൻ ഉണ്ട്. നമ്മൾ ഹെൽത്ത് ഇൻഷുറൻസ് ഒക്കെ നമ്മളിവിടെ ലൈഫ് ഇൻഷുറൻസ് എടുത്തിടുന്ന കണ്ടീഷനാണല്ലോ. നമ്മളിവിടെ ലൈഫ് ഇൻഷുറൻസ് എടുത്തിട്ട് കഴിഞ്ഞാൽ നമുക്ക് എന്തെങ്കിലും സംഭവിച്ചു കഴിഞ്ഞാൽ നമ്മുടെ പേരൻസിന് അത് കിട്ടുമോ, അതോ നമ്മൾ ബില്ല് എഴുതി വെച്ചാൽ മാത്രമേ അത് പേരൻസിന് പോകുള്ളൂ? എങ്ങനെയാണ്?
Ideally അങ്ങനത്തെ സംഭവങ്ങളിൽ where we have life insurance policies and all have beneficiaries listed. അപ്പം എന്തെങ്കിലും സംഭവിച്ചാൽ അത് ആർക്ക് പോണോന്നുള്ളത് സോ ഐഡിയലി ആ ബെനിഫിഷ്യറി ആരാണോ നമ്മൾ നെയിം ചെയ്തേക്കുന്നത് അവർക്കാണ് the first preference.
ഓക്കെ. അതുപോലെ ഹെൽത്ത് ഇൻഷുറൻസിന്റെ കേസിൽ നമ്മൾ ഇൻകപ്പാസിറ്റേറ്റഡ് ആയി കഴിഞ്ഞാൽ അതിന്റെ സിനാരിയോയിൽ എങ്ങനെയാ വർക്ക് ചെയ്യുക? ലൈക്ക് ഇൻഷുറൻസ് ഉണ്ടെങ്കിൽ ഇൻകപ്പാസിറ്റേറ്റഡ് ആയി കഴിഞ്ഞാൽ നമ്മുടെ പേരിലുള്ള ഡിസിഷൻസ് എടുക്കാനായിട്ട് ആർക്കാണ് നമ്മൾ പവർ കൊടുക്കുക? അതിന് ഈ ബില്ല് വേണ്ട ആവശ്യമുണ്ടോ?
അല്ല, അത് will only come into effect after one passes away. And മുമ്പേ സർ ഇപ്പം സംസാരിച്ചത് മൊത്തം ഒരു SDM substitute decision maker when you are mentally incapacitated but you're still alive and to make those healthcare decisions for you. So would you like to add to that? എബി ഒരിക്കൽ കൂടെ ആ ചോദ്യം ചോദിച്ചാൽ ഐ തിങ്ക്
ഞങ്ങള് സ്റ്റുഡൻസ് ആയിട്ട് വന്നിരിക്കുന്നവരാണ്. അപ്പൊ സോ ലൈക്ക് നമുക്ക് എന്തെങ്കിലും ലൈക്ക് ഇൻകപ്പാസിറ്റേഷൻ വന്നു കഴിഞ്ഞാല് അപ്പം നമ്മുടെ ഹെൽത്ത് കെയറിന്റെ ഡിസിഷൻസ് എടുക്കാനായിട്ട് നമ്മൾ ആരെയെ ചുമതലപ്പെടുക? അതിന് റിട്ടേൺ ആയിട്ട് നമ്മൾ എന്തെങ്കിലും ബില്ല് പോലെ എന്തെങ്കിലും എഴുതി വെക്കേണ്ടതുണ്ടോ? അതോ ഓട്ടോമാറ്റിക്കലി?
അതാണ് ഞാൻ മുഴുവൻ പറഞ്ഞത്. അഡ്വാൻസ് കെയർ പ്ലാനിങ്, നമ്മൾ അതിൽ തന്നെ നമ്മൾ എന്തെങ്കിലും സംഭവിക്കുന്നതിന് മുന്നേ നമുക്ക് ആരോഗ്യമുള്ള സമയത്ത് തന്നെ ഒന്നോ അധികം ആൾക്കാരെയോ കണ്ടുപിടിച്ച് സബ്സ്റ്റിറ്റ്യൂട്ട് ഡിസിഷൻ മേക്കേഴ്സ് ആക്കണം. മാത്രമല്ല അവരോട് നമ്മളുടെ ആഗ്രഹങ്ങൾ, ഇപ്പൊ ഇങ്ങനെ എന്തെങ്കിലും സംഭവിച്ചു കഴിഞ്ഞാൽ എന്തൊക്കെ ചെയ്യേണ്ടത്, ഏത് രീതിയിൽ പോകണം, ട്രീറ്റ്മെന്റ് ഏത് രീതിയിലുള്ള വേണം എന്നൊക്കെ അവരോടും പറഞ്ഞ് മനസ്സിലാക്കി വെച്ചേക്കണം. സോ ദാറ്റ് they can act according to your wishes. Now അതൊന്നും ഇല്ലെങ്കിൽ, ഇപ്പൊ സപ്പോസ് യു ഹാവ് പവർ ഓഫ് അറ്റോർണി ഒന്നും ഉണ്ടാക്കിയിട്ടില്ല, there is no legal document, അങ്ങനെയാണെന്നുണ്ടെങ്കിൽ നിങ്ങളുടെ ഫാമിലി മെമ്പേഴ്സ് ആരെങ്കിലും ഇവിടെ ഉണ്ടെങ്കിൽ ഹൈറാർക്കി അനുസരിച്ച് that person becomes the SDM, and the doctor or the healthcare workers will take their decisions. They can decide for the person. അങ്ങനെ ആരും ഇല്ല, റിലേറ്റീവ്സ്, ഫാമിലി റിലേറ്റീവ്സ് ഒന്നും ഇല്ലെങ്കിൽ, then it becomes difficult. അവസാനം ഈ പബ്ലിക് ട്രസ്റ്റി, ഗാർഡിയൻ അവരൊക്കെ വരും ഡിസിഷൻ മേക്കേഴ്സ് ആയിട്ട്.
So we need a written document എന്നാണോ പറയുന്നത്? റിട്ടൺ ഡോക്യുമെന്റ് ഓതറൈസ് ചെയ്യാൻ വേണ്ടി നമ്മൾ റിട്ടൺ ഡോക്യുമെന്റ് ഉണ്ടാക്കി വെക്കണം എന്ന് തന്നെയാണ് പറയുന്നത് ഇങ്ങനെയുള്ള കേസുകൾ?
യെസ്, അതാണ് പവർ ഓഫ് അറ്റോർണി. യു ആർ deputing somebody to make decisions for you when you are incapable. എന്തെങ്കിലും അസുഖം വന്നിട്ട് എന്തെങ്കിലും സംഭവിച്ചിട്ട്, if you are unconscious or if your level of consciousness is not good enough to make decisions, then at that time നമ്മൾ പവർ ഓഫ് അറ്റോർണിയിൽ പറഞ്ഞേക്കുന്ന ആരാണോ, he or she can make decisions for you. അതിപ്പോ ആരെങ്കിലും ഫാമിലി മെമ്പേഴ്സ് ആയിരിക്കണമെന്നൊന്നുമില്ല, ഫ്രണ്ട്സ് ഇവിടെ ഫാമിലി മെമ്പേഴ്സ് ഒന്നും ഇല്ലാത്തവരാണെന്നുണ്ടെങ്കിൽ they can make your friend or friends as the STMs, power of attorney.
Thank you.
I'm just aware of the time. Dr. Chemparathy, Chris, are you okay to take a few more questions?
Sure. I'm okay, yeah.
Okay, thank you. I think George had a hand up. George's iPhone.
Yeah. Thanks. Actually, the question is to Chris. As per the Chris presentation, it is mentioned that if somebody died without a will, if it is 200,000 or less, it will go to the spouse, and the remaining will be equally divided to spouse and kids. Am I right? But in that case, what is the point of making a will? Is there any risk if not making a will? Is there any advantage of making a will in such case? If somebody want to go the property to the spouse and children.
George, I think maybe you misread my presentation, or maybe I was a little too fast. My apologies for that. So I'll clarify. If you die without making a will, if you're legally married and you have no children, then everything goes to your spouse. In the next scenario that I said is, if you're legally married and you have children, and if your net worth is less than 200,000, all goes to your spouse. So that is how Ontario looks at it. Or different provinces treat the preferential share differently. So the Ontario rule ana. So the first 200,000 is what goes to the spouse, and the remaining will be divided between the spouse and the children. 200,000 the more lower.
പ്രശ്നം വരുമോ?
എന്തോ
എന്തെങ്കിലും ടാക്സിന്റെ പ്രോബ്ലം വരുമോ ഇത് ലീഗലി ട്രാൻസ്ഫർ ചെയ്യുന്ന സമയത്ത്? അങ്ങനെ എന്തെങ്കിലും ഉണ്ടോ?
ഐഡിയലി അതാണ്, അതുകൊണ്ടാണ് നമ്മൾ പ്രൊഫഷണൽസിനെ ഇൻവോൾവ് ചെയ്യണമെന്ന് പറയുന്നത്. കാരണം there are different ways to work around the titles to property that will help save on the estate administration tax when these things have to eventually pass on to the beneficiaries. അപ്പം മിക്കവാറും സ്പൗസസ് ആവുമ്പം നമ്മൾ റെക്കമെൻഡ് ചെയ്യാറുണ്ട് പ്രോപ്പർട്ടീസോ കാര്യങ്ങളോ എല്ലാം പ്രെഫറബിളി ജോയിന്റ് നെയിംസിലാണെങ്കിൽ ഇറ്റ്സ് കോൾഡ് ജോയിന്റ് ടെനൻസി. അപ്പൊ അങ്ങനെ വരുമ്പം നമുക്ക് ഒരാൾ മരിച്ചു കഴിഞ്ഞാൽ അടുത്ത ആൾക്ക് ഓട്ടോമാറ്റിക്കലി അണ്ടർ ദ റൈറ്റ്സ് സർവൈവർഷിപ്പ് റൈറ്റ്സിൽ യു ഗെറ്റ് ദ പ്രോപ്പർട്ടി. ടാക്സേഷൻ ഇംപ്ലിക്കേഷൻ ഇസ് ഡിഫറെന്റ്. അപ്പം there are different ways to treat it depending on what kind of assets you have and what is the nature of the assets that you hold. So yes, they can be differently devised and very creatively devised. We can have multiple wills. We can do a lot of things. So it just is dependent on your particular scenario.
Okay, thank you.
Sajid, I think you had a question. Do you want to ask it out loud, or I can read it?
I think Sajid was asking that can POA and SDM be two different persons? Can we list couple of people as POA or SDM? Like in the absence of A, B will be my POA. So would you like to answer that question? I can if you don't want to.
Yeah, sure. So SDM, substitute decision maker, പല provinces-ലും പല പേരിലാണ് അറിയപ്പെടുന്നത്. ഒണ്ടാരിയോയിൽ അവരെ അറ്റോർണി എന്ന് പറയും. അതുകൊണ്ടാണ് നമ്മൾ പവർ ഓഫ് അറ്റോർണി എഴുതുന്നത്. സോ ഒണ്ടാരിയോ province-ൽ SDM ആണ് അറ്റോർണി. They are the same, one and the same. So you can have one or more persons as attorneys or substitute decision makers. Isn't question?
ഒരാളില്ലെങ്കിൽ വേറൊരാളെ നെയിം ചെയ്യാൻ പറ്റുമോ?
ഒരാളില്ലെങ്കിൽ വേറൊരാളെ നെയിം ചെയ്യാൻ I don't know. I think you should.
I can answer that for you, sir. So yes, absolutely. So for example, you can have multiple people and you can have them in different capacities, in the sense acting. For example, let's say you can name A and B to act jointly or severally, and if A and B are not there, then C to act. So, or you can have C and D to act. So namak ishtolla perigale namak, you know, avoiding too much of potential for conflict. Karanam chela samayathu nammal ottri pere name cheyidu kaniyumbom adum issue aanu. So yes, absolutely, to answer your question, namakku we can have more than a person and we can have substitutes, and we can do that also creatively.
Thank you, Chris.
Thank you.
No problem.
Any other questions? I think that's it. Thank you. All right, so we'll close with that. Thank you, Chris, for your very clear presentation, and you've been so available for so many topics. Yep. Jibianko, go ahead.
Okay, one request I have, Dr. Joseph and Chris. Could we have this presentation for the Knights of Columbus at a date which is acceptable to you?
I would be honored to present with Dr. Joseph Chemparathy once again. So I'm more than happy to do it. So whenever sir is available, I will make myself available.
Yeah, it's okay with me too.
Thank you very much.
Yeah, sure.
I'll set up the appointment with you and find the possible date, and then Jojo Chinimbulikam.
Thanks, Jibianko. And Jaren will also be making this into a video, and I think you'll be able to find it if you search SMYM Canada. So if any of the participants, if you want to share it with your friends and your colleagues, that's really why we've done this session today. Please do that, just to get the conversation started. Anyway, so thank you, Chris, for being available. Thank you for your clear presentation. Thank you, Dr. Chemparathy, for volunteering, being voluntold to do this. You've done a very clear job, and I really appreciate your experience. So thank you to both of you.
And thank you, Dr. Mimi, for being the moderator. Good moderator that.
Thank you. Thanks, Jibianko.
Thank you.
Thank you. എല്ലാവരുടെയും പേരിൽ ഈ നമ്മുടെ സ്വന്തമായ വിശിഷ്ടാതിഥികൾക്ക് നന്ദി പറയുവാനായിട്ട് ജെറിൻ ആരെ ഏൽപ്പിച്ചേക്കുന്നത്?
ഡോക്ടർ ബേബി തന്നെയാണ് നന്ദി
ഓക്കെ.
I can do it again if you want.
No. Thank you so much.
Thank you. ഞങ്ങളെ സന്തോഷവാന്മാരാക്കുന്നു. അപ്പൊ ജിമ്മി ചേട്ടാ, ഒന്നുകൊണ്ട് പേടിക്കണ്ട. ഇവർ രണ്ട് ഞങ്ങളുടെ റിസോഴ്സ് പേഴ്സണെ നിങ്ങളുടെ ആവശ്യങ്ങൾക്ക് ഞങ്ങൾ വിട്ടുതരുന്നതായിരിക്കും. അത് അണ്ടർഗ്രൗണ്ടിൽ മേടിക്കണം, പുറത്തു പറയാൻ പറ്റില്ല. അതെ. അയ്യോ, ഓക്കെ.
Thank you, everyone. Thank you so much. Thank you, doctor.
Thank you, Jarin.
Okay, good night.
Everything okay, Jarin?
Thank you. Good night.
We will see you on Wednesday, right?
Yeah.
Thank you.
Thank you.
Thank you.